the Grammys, right? Do over. Okay. So, international law. So, historically, international law has addressed relations between what we call states or what we call countries. States in the international context refers to countries. And historically, it's addressed some limited areas. War, human relations, diplomacy, and commerce, which is business, global business. And international law is really dependent upon the sovereignty and what we call territorial boundaries of a particular country or state. So sovereignty refers to the ability of a country to be in charge of all the people and things within its territory. That's what sovereignty means. So in today's world, due to the increased globalization of our world, meaning people interacting with each other more and more, and the things that we do in one country affecting people in other countries, the scope and authority associated with international law has grown. It's gotten a lot broader. So things that we do in our country affect things in other countries. And so therefore we can say that globalization has accelerated or caused the scope of international laws to grow. So what exactly is an international law? An international law is a set of rules that countries follow in dealing with each other. It requires us to think about our notions of sovereignty. Because if sovereignty is the ability of our country to manage its own people and be in charge of its own people and things, globalization impacts our ability to have sovereign control over our own people. Okay? And the reason that we say that is because to the extent that a country puts into place a law, or we have international laws that we agree to, it might impact whether we can do or not do something as citizens of the United States. So some areas of developing international legal relations are areas involving the environment, areas involving human rights, international trade, meaning economic laws, and also the laws of combat. So, for instance, if you think about it, what's going on in Syria? Basically civil unrest, right? There's a war going on in Syria. It's really mostly an internal conflict, but have other nations gotten involved? Yes, many other nations. Some would argue Russia, United States, many other countries, whether they're directly or indirectly impacting or involved in that war within Syria. Are there any environmental implications? Sure. Okay, think about that. Many of their cities are literally destroyed. Do you think there's air pollution from the bombing? Yeah. Do you think human rights violations are taking place? Absolutely. Look at the children that they're gathering up, and they're orphaning so many kids and killing women, and so many things that we in our country would deem to be wrong. But are we interceding? Are we getting involved directly or indirectly? Yeah, we are. And so are we, in effect, basically impacting international law by getting involved? Sure, we are. Absolutely. How about, did anybody hear about North Korea bombing, sending up a missile at the end of last week? Yeah. Okay. How many countries do you think are worried about North Korea sending up a missile last week? It's a lot of countries that are very seriously concerned. Our country, Japan, who was here visiting, they literally sent it out into the Japan Sea. Japanese are definitely concerned. So there's a lot of things going on that are shaping how countries deal with each other. And that's where the area of international law is plays. Now, but then you have countries like North Korea who don't want to play nice in the playground, so to speak, right? They want to do their own thing. They want to be very sovereign, right? They want to do what they want to do. So again, does that become a problem? So, what are some sources of international laws? Some sources are international customs, which are just general practices similar to our common law. When we talked about our sources of law in the United States, we said one of our sources of law is common law, how traditionally we've handled things. Well, same here in the international realm, okay? Generally, how things have evolved over time. Then we have treaties and international agreements. These treaties are basically just contracts between two or more countries. They can have their own rules for enforcement, and they can have their own rules for how disputes are handled. Then lastly, we have international trade organizations or conferences that come together to basically hash out how certain things should be handled and then try to come up with an agreement or some sort of law that they establish. Secondly, we have these things called principles. The first principle is called the principle of comity. The principle of comity basically addresses how one nation will defer how to handle a situation and give importance to the laws and decrees of another country, as long as those laws and decrees of that other country are sort of consistent with the law in the original country. So for instance, where would this come into play? So let's just say we had a company from the United States and a company from Sweden. They entered into a contract. Let's say the United States company breached the contract or basically didn't live up to their part of the agreement. So the Swedish company sues the American company in Swedish courts. Okay? The courts decide the case and determine that the U.S. company is guilty and the U.S. company needs to live up to its agreements. In order to resolve this, then the Swedish courts will approach the American court system, and basically the American court system will review that contract and make a determination as to whether or not they agree with the Swedish courts. So if they did, then the U.S. company would have to abide by the contract. They would have to live up to their terms, or basically compensate the Swedish company for the breach. Okay, that's a principle of comity. Second doctrine is the act of state doctrine. It basically says that the judicial branch of one country will not examine the validity of public acts committed by a recognized foreign government within its own territory. And we have the two concepts of expropriation and confiscation. So what expropriation means, it's basically that the government of another country has the right to seize, God bless you, seize the assets of a business from a foreign country. So if the United States opens up a gold mine, if a company from the U.S. opens up a gold mine in Venezuela, and for some reason the Venezuelan government determines that they want to take over that gold mine, that company can basically say, under expropriation laws, you've been compensated by owning the gold mine and reaping the benefits of the gold mine up until this point. But from this point forward, that gold mine belongs to us. It's in our country, and we have the rights to the assets of that gold mine. The other way that a foreign country can take over is through confiscation. And this is basically if that foreign government seizes the assets of another country's assets and says that they've been operating illegally. So in a confiscation, it's more of an illegal situation. In an expropriation, they're basically going to take it over because they believe it's theirs. Okay? Either one is not something that you would want to have happen to you if you're a business owner. So that's part of the risks, though, of entering into business in a foreign country. It's definitely a risk that businesses have to take into consideration and evaluate when they decide to enter into a foreign country. It's why, in many instances, U.S. companies will not necessarily open a business in, countries where there's a lot of unrest, because they are concerned that the foreign government might take over their business. And if you go through the whole process of starting up a business, maybe building buildings, et cetera, and then have them taken over, it's obviously not something that you want to see happen. So it's a risk that you have to evaluate before you go and enter into business. So businesses do things to mitigate that risk or minimize it, and we'll talk about that. Lastly, principle of or doctrine of sovereign immunity basically says that the circumstances in which an action may be brought in the U.S. against a foreign nation, including a foreign nation's property, it outlines this, the doctrine of sovereign immunity, and it basically says that foreign nations are exempt from the jurisdiction of the U.S. courts, except in the following situations. So foreign nations are exempt from the U.S. jurisdiction, the jurisdiction of U.S. courts, except in cases where the state waived its immunity. So, for instance, if the state, meaning the foreign country in this case, waived its immunity. Cases involving commercial activities carried on in the U.S. by a foreign state, or cases involving a tort committed in the U.S. or violations of international law. So, in those cases, sovereign immunity would be waived. So, how do businesses in the U.S. deal internationally? First, they can do exporting. Second, they can establish a foreign production facility. Or third, they can establish some sort of licensing agreement or licensing situation as it relates to copyrighted or trademarked products. And I'll explain these. So exporting. This is basically when U.S. firms brings products or goods to foreign markets. Two forms. There's what we call...
Can you just go back for a second?
Oh, so sorry. Back to this one?
Yeah.
Oh, sorry. Yeah. Good? Okay. So two forms of exporting. First form, direct. This is where we basically sign a contract and sell directly to foreign purchasers. It provides us with, we sell it to them, we ship it, all the sales are direct from us to whomever the customers might be. Second way is through indirect. This is where we might be dealing with an agent or distributor of our products in that foreign country. So we would sell it to somebody who is a distributor out in that country, and then they would sell it to the actual end user. In the indirect situation, somebody else is going to be negotiating on our behalf, our country or our company's behalf. Good or not good? Good. Okay. Second way that we deal in foreign countries is to establish a foreign production facility. This is where we would go into another country and actually set up a facility. And we would look to do this because we believe that we can reduce our labor costs or potentially our shipping costs by setting up a whole operation in that country. So for instance, if we wanted to maybe set up an operation in, say, Europe, let's say, for instance, we wanted to set up a car manufacturing facility in Europe of our Ford cars, Okay? They would set up a whole building and facility, maybe because the labor and shipping of the product would be less if we just set it up there. We believe that it helps us to compete more effectively in that market. Lastly is licensing. This is where we might set up a situation where we actually provide authority to another company in that foreign country to manufacture on our behalf those products. A very typical situation is Coca-Cola. So everybody knows Coca-Cola has a very secret patented formula for its syrup for its Coca-Cola products. So what Coca-Cola does, it doesn't have per se facilities in other countries. What they do is they sell the license to use the syrup and manufacture the syrup to these foreign companies, and then the foreign company then turns around and sells Coca-Cola products in those countries on Coca-Cola's behalf. Okay, so they're licensing manufacturers. So here's a case, and let's see how you guys think we should decide this case. So we have Fuji Photo Film versus the International Trade Commission. And in this particular case, we're trying to decide, did Jazz Photo Corp violate a cease and desist order, and why you think they did. So a cease and desist order means that you have to stop doing something. Okay. So here's the case. Fuji Photo Company owns 15 U.S. patents for what they call lens-fitted film packages, LFFPs. Basically, those little small disposable cameras. Okay, so they have 15 patents on those disposable cameras. They're popularly known as disposable cameras. An LFFP consists of patented plastic shell, the outer shell, loaded with film. To develop the film, a consumer gives the LFFP, the actual device, to a film processor and receives back the negatives and prints, but not the shell. So you guys buy the little camera, you bring it into CVS. CVS takes the film out of the plastic shell, throws the little plastic shell into a bin, and then processes your film and gives you back your negatives and your pictures. So Fuji makes the shells, makes those shells, those LFFP shells. Jazz Photo Corp collected used LFFP shells in the U.S., shipped them abroad to another country to have new film loaded into them, and then imported them back into the U.S. for resale. Fuji had an issue with this because they had a patent on those LFFPs. The International Trade Commission determined that Jazz's resale of the shells originally sold outside the U.S. infringed on Fuji's patent. In 1999, the ITC issued a cease and desist order to Jazz to stop importing those back into the U.S. While the order was still being disputed in the courts between 2001 and 2003, okay, Jazz imported and sold 27 million refurbished LFFPs. Fuji complained to the ITC, which fined Jazz more than $13.5 million. Jazz's CEO appealed the U.S. Court of Appeals, appealed to the U.S. Court of Appeals for the Federal Circuit because this is a case that has federal jurisdiction. And so the question is, how many of you think that Jazz Photo violated the cease and desist order that the ITC originally put out? How many people think they did? Go ahead. How many people don't think they did? Okay, so why do you think they did? Right, Nicole, you raised your hand. Why do you think that Jazz violated the cease and desist?
Well, I'm not really sure what cease and desist order is.
It means that they have to stop selling it. They have to cease and desist means, stop.
Because they kept selling them in the U.S.
And the ITC order said they had to stop.
Yeah.
Okay. Who else? there were a couple people that agreed with her. Who doesn't think they violated it? Cam.
I don't think they did because they're still being disputed. It wasn't in effect until 2003.
Okay, so I'm going to say that they did, the ITC did, or the circuit court did decide that they did violate the cease and desist order. So Jazz did have to stop, and they did end up having to pay the Fuji for the violation, okay? So let me explain a little bit how that went. So what happened is, it went to the ITC. The case went to the ITC. The ITC issued a cease and desist, but then, so that was the first ruling, okay? Then, and we'll talk about, they still lost. They lost the appeal as well. Okay. So last piece here. International law is continuing to evolve. Our laws in the U.S. obviously are still changing, as are international laws, and laws in general just need to meet the changes of society and in today's world of both society within a sovereign country and internationally. Okay? All right. We're going to stop.